seeing the screen, the first slide?
Criminal Court Practice.
Yep, 2020.
Presenter
Okay.
Prophet Muhammad. I can see it.
Perfect. Perfect. Thanks, Prudence.
I'm going to leave the site now, but you can reach me on my cell if there's anything that you need.
Thank you very much.
Thank you.
Okay. Good morning, class. I'm hoping that you can all see the screen. I think that just to start from the front and to say that, you know, I think for most of us, the experience with online learning, it's the first time that I'm presenting online as well. So I would certainly ask that you bear with me as well, particularly trying to work some of these slides and make sure that you can see what needs to be seen. I will also make the slides available. I'll forward it on to Prudence, and hopefully she can then disseminate it to each of you by email, so that you can avoid unnecessarily having to write feverishly, taking down all of the notes. If you're having problems hearing me, then just let me know. But I'm going to assume that unless somebody informs me that you're having trouble hearing me, that you can all actually hear. For purposes of today's session, and in comparison to what we'll do in the face-to-face, or what's intended to be done in the face-to-face, I think it's just important for us to understand what the objectives are of these sessions. So, as you will see from the slides, the objective is here clearly not to reteach that which you already have been taught in the substantive law at university. The idea is not to teach you criminal law and the principles pertaining to specific crimes and the elements and those things. It is to assist you in trying to come to terms with some of the practical realities of criminal court practice. Yes. Yes, you can speak.
Professor Musa.
Yes.
I can't see any slides on my side. I can't see this. I can't see the slides.
You can't see the slides.
It happens sometimes. You can just log out and log back in again, then you'll be able to see it.
And so some of you can in fact see it, but some of you can't.
Yes.
Yeah.
Yes,
Okay.
you have to log out and
you just
log
have
in
to
again.
log out and then log back in.
Okay. And so which slides are you seeing at the moment? Is it slide 1 and 2?
Yes.
Okay. All right.
Criminal Court Practice 2020.
Yes, Criminal Court Practice 2020. So there'll be a slide 1 and there's an introduction slide as well. So are you seeing only slide 1 at the moment?
Yes.
Okay.
Yes.
Are you seeing slide 2 at the moment or just slide 1 still?
Slide 1. Now slide 2.
Okay. Okay, that's slide 2. Okay, so now I have an idea also as to what you are saying. And perhaps what I'll do is, as I'm scrolling down, I will also just mention so that I sort of talk you through it, so that if there is a problem, then you can just alert me to it. But
Okay, I'm just going to log out quickly.
Not a problem. Just so that we are all on the same page insofar as some of the objectives. We won't start until we've got people back in, but just to give you some context to what we are trying to achieve, so that you also understand what is to come, particularly in the contact session. So what I usually do in the contact sessions, and I've been doing this for the past few years that I've been teaching this part of the course, is that in the contact sessions, what we do is we do mock trials. So we actually do preparation of a set of documents for court, pleas, we do arguments. So I would present the students in the contact session, break you up into little groups, and then present you with a set of facts. So everybody will get the same set of facts, but different people will approach it from different parts. So it'll be like running a full trial from start to finish, so that you can actually see the different stages of a criminal trial. So from an opening statement through to a sentencing of an accused person, including cross-examination, examination in chief, doing a bail application, doing a plea. So different students will get to do different parts of the same trial, but from a very practical orientated perspective, not necessarily focusing exclusively on the substantive law, but looking more particularly at some of the very practical skills that is needed from a person practicing in this particular area. And so when doing that part of the work, what this first session is then intended to do is to try and familiarize you with some of the skills, some of the techniques, some of the guidance that you will need in order to be able to maximize your experience in the second contact session this year, which is in the actual presentation of either a cross-examination, examination in chief, or doing a consultation, whatever the case may be, to present a criminal trial in one of the lower courts. So that is some of the objectives that this session is intended to achieve. And that is how, as we're going through today, that is what you need to please keep in mind, so that you understand from what perspective this course is being presented. It is certainly not intended to teach and reteach the substantive law. I'm going to assume, as I put there on the slide, I'm going to assume that you have the relevant substantive law knowledge. So insofar as how we are going to proceed today, before I get into the third slide, we are at 5 to 9 at the moment. So what we'll do is we'll carry on till about 10:15 and then break for about 15 minutes for some tea, and then resume and proceed until about 12 or so. What I am hoping that we can possibly agree to is to possibly have a shorter lunch, so that we can maybe start a bit earlier and finish the afternoon session somewhat earlier than the scheduled 3:30 or so. If you have any objections to a shorter lunch or to us finishing earlier in that way, then just let me know. But I'm not averse to us having a shorter lunch break in order that we make up some time and ending a bit earlier. I know it's Friday and a lot of you might have other things that you want to start early in the afternoon. But just let me know as the day progresses as to whether you would want an earlier lunch or a shorter lunch. But before we start, perhaps it's a good idea just to try and make the point that you know, with these sessions and when I do it in the contact sessions, I try to keep it as not just as practical as possible, but to get the colleagues that are attending to engage with me as much as is possible. A lot of this is intended to have practical value and to add some value in your practice as candidate attorneys going forward. And I understand that some of you have an interest in this area. Some of you, I understand, are doing this simply because it's a compulsory course. Some of you, I know, have experience in criminal work and some may not have. So perhaps it is good at the start for me just to get a sense from those who are prepared to engage, just to get a sense of how many of you, or indicate those of you who have experience in criminal work and what your experience has been, what some of the challenges are, and what you would like to achieve from this session and the next session. If I can have an idea as to what some of your objectives are, what some of your aims are in what you would like to see coming out of this, I can make a note of that and try to ensure that as best I possibly can, that the kind of value that you want to see is actually achieved by this course, as opposed to me simply presenting that which has been prepared. I think it's important if you get benefit out of this, the kind of benefit that you would like to have. So for those of you who are in this session, perhaps some of you can start and give me some ideas as to what some of your aims are or wishes that you would like to achieve in today's session and the next contact session. You can simply join in and start, and then we can take it one by one. There were a number of you who had questions for Prudence, and I'm hoping that you and others would have things to say regarding criminal court practice. Anyone with some experience in criminal court that you would like to share?
Good day, Prof. My name is Celeste. I did my articles at both criminal and civil firm. So I have experience with bail applications, but I haven't done a trial yet. So I'm quite interested. I've watched the trial, but I'm quite interested in the that procedure, sorry, and then also what I see here, the specialized commercial crimes.
Yes.
So be very interesting for me.
Yes. What exactly have you observed about a criminal trial? What have you seen that is different to your bail application experience? Maybe you can share with us some of your experience. Where in which court was this, and what exactly was the charge, and how do you think your performance went?
It was drunken driving, and well, when I looked at the, I wasn't there long enough to complete because we had to do different things. But with the bail applications, it was pretty straightforward for me because my principal was there guiding me. But the trial looks a bit more interesting, and the consultations and used. So that would also be.
So when it came to the consultation, did you attend to the consultation yourself, or was that done by a colleague and you just did the actual bail application itself?
I did the consultation before the bail application.
Okay. And was that consultation, I take it, one that you either did in the cells with the accused, or you went to the prison and you interviewed the person in the prisoners section?
It was at court in the cells.
In the cells, yes, yeah. So you went down into the cells.
Yes, I did. So.
All right. Okay. Okay. Thanks, Celeste. Anyone else has an experience that you would like to share in your criminal court experience? I'm sure Celeste cannot be the only one that has some experience, even if you're not personal experience. If you've been with your principal and you've observed things happening, what are some of the things that you've observed that were unclear to you that you might want explanation on here, that you might want to use this opportunity? Anyone? Yes?
I have no actual
If you can
experience.
if you can identify yourself so we know who's speaking.
I'm sorry, I'm Shalita.
Shalita, yes.
Yes, I'm a candidate here at Joubert van Vieren in Ceres. I kind of love criminal law and want to specialize therein. I've had a few cases, but I've never witnessed the trial. I've managed to negotiate or plea deal most of the matters that I had, or most of the clients that came to me. So I'm really interested in this class, and especially in the procedure to take the whole trial for a completed trial.
Yes, yes. Tell me, Shalita, you say that you've done mostly pleas. So I take it that you've done a lot of section 112s and 115 written pleas, and you've got quite a bit of experience at that.
Yes, I've done only one of those. The others I negotiated with the prosecutor in chambers, mostly to get a lesser sentence or a guilty plea without a fine or whatever the case may be in the certain circumstances.
So then you've taken your client from the stage of plea all the way to the plea and then the sentence phase?
The sentence phase is out that I was supposed to do. I had something, I think I had a doctor's appointment with my colleague. Yeah.
Okay, but then you've done part of the trial phase. I mean, you said that you didn't have trial experience. A trial is not only the trial where you're running with a witness. So any proceeding in which you would have been there when the charge was made, when the charge was read out, you would have been there, I suppose, when your client was asked to indicate what his plea is, and he would have indicated, in this case, I suppose, a guilty plea. And you would have then stood up and probably said to the magistrate, Your Worship, my client's plea is in accordance with instructions that he gave. And that your magistrate would then probably have asked you if you prepared a written plea, and you probably would have said yes, and you would have read the plea into the record after the prosecutor has gone through it himself and has indicated to you that he's accepted the terms of the plea. And after the magistrate heard the plea or read the plea, he probably then would have gone through it and make sure that the plea contains an admission to all the relevant elements. And then if he was satisfied, he would have found your client guilty. And that's until when you took it and your colleague would have done the sentence phase. So you've done part of a criminal trial proceeding. What you probably haven't done then is the cross-examination and examination phase of a trial process, and you probably haven't done the rest of the processes. So when we do the next session, in the contact session, you will get to see that part of it. And in today's session, I'll try to explain the different phases in a criminal trial, and hopefully then you will be able to see where what you did fit into this, and the rest of it that you haven't yet participated in, how that will then unfold. Maybe if somebody, so we've got Shalita and Celeste. who else has got some criminal experience, if not practical, then through observation? And what has your observations been?
Hi, Prof.
Yes, you are?
Yes, I'm Tamsang. I work at Legal Aid in Cape Town.
Tamsanga. Yes, Tamsanga.
Yes, I've done trials, bail applications, and I've also entered into a plea agreement with the senior prosecutors, the section 105A.
105A, yes.
Yes. But I haven't done most of the opposed bail applications. Most of my bail applications were unopposed, so it was a simple matter of me just reading the affidavit into the record.
Yes.
So I do hope, yes, it's not ideal, but I do hope to get an opposed bail application just to get the experience and put my client on the stand instead of me just reading the affidavit.
You do know that, yeah, that with the opposed bail applications, with these bail applications, one tends not to try to put your client in the witness box for the bail application itself. What tends to happen with these opposed bail applications, most of the part that is opposed, in a sense, is the state opposing your client wanting bail. And so what generally happens, if you remember with the Oscar Pistorius bail application, what generally happens is what happened in that matter, and that is that the investigating officer would go into the witness box and he will testify as to the reasons why he, on behalf of the state, is objecting to the accused getting bail. And as the attorney acting for an accused, you generally would be there to cross-examine the investigating officer in relation to the grounds that he is using to oppose your client's release out on bail. Generally, in most of these opposed bail applications, generally the accused will not be going into the witness box as such. Generally, the accused affidavit is going to be used for that purpose. Most attorneys and practitioners would focus on the investigating officer, and that's when your skills in cross-examination become so important, because by and large, you are trying to convince the presiding officer that your client should be let out on bail, and if the state is opposing it, it requires a good cross-examination in order for you to elicit the necessary information and concessions from the investigating officer. And so what you haven't done, insofar as an opposed bail application goes, it would seem, you've done half of a bail application in the sense that you've done your client's part. You've done the usual thing of the affidavit. What you seemingly haven't done, Tamsanga, is the cross-examination of an investigating officer. Have you dealt with investigating officers in your experience? I'm sure that you must have at some point. Tamsanga?
Yes, Prof. I've actually not had the opportunity to deal with them. What they usually do, they just leave an affidavit in court, and I actually have a problem with that, but I just don't know how to address it, because they always leave an affidavit and not give me the chance to cross-examine them on the reasons why they're opposing the bail application.
Is that what they're doing?
Yes, they leave an opposing affidavit.
But yeah, you need to then, if they're opposing it, surely the if they're opposing it and it's a formal opposed bail application, if it comes to court as a formal opposed bail application, if the burden of proof is on the state, then invariably the prosecutor would have to lead the evidence if he's simply bringing an affidavit. And is the prosecutor presenting the affidavit to the magistrate?
Yes, Your Worship. Sorry, Prof.
Yeah. Well, then you need to tackle that. You need to tackle the facts in that affidavit, and you perhaps need to make an argument as to why they should bring the investigating officer there, because you are disputing critical aspects of that. Your client has a right to cross-examine his accuser, and at this stage of the proceeding, if it's the investigating officer, you could probably try to make an argument that your client is being severely prejudiced in that allegations are being made in an affidavit that you can't test, because the person making the affidavit is the state investigating officer who is refusing or is unavailable or whatever the case is. And you then need to make an argument as to why the court needs to discount the facts that are being stated there. So it's about your approach, how you then approach the matter, the skills that you bring to the table and to the matter to try and argue why your client should not be prejudiced as a result of the manner in which the state is presenting its evidence. Have your bail applications been what, Schedule 5 or Schedule 1, or what has it been?
Generally Schedule 5. Schedule 1, they never oppose. So
Yes.
what the magistrate would, the prosecutor would just ask for it to be fixed at a certain amount, and if the client can afford, then the bail will be fixed at that amount. And yes.
Okay, so what becomes important for our purposes here in the course, and for those listening, when we do in the contact sessions, when we're going to go through the practicals, it becomes important that you familiarize yourself in advance of the contact session with particularly Schedule 5 and Schedule 6, so that when we do practicals, for those of you who are going to be doing a bail application or the bail application part of the process, that you understand what some of the requirements are, the evidential requirements, where the burden of proof lies in order to secure the release of an accused at a bail application under either Schedule 5 or Schedule 6. Thanks, Thamsanqa. So, anyone else? Let's get some. We're getting some useful experience that individuals have in relation to what you've done up until now, so that I can get a sense of the level of experience and what some of your needs are, what some of the things are that you would like to achieve in today's process. Who's next? We've had 3, Celeste, Shalita, Thamsanqa. We've got quite a full class, so I'm sure that there's some others that may have experience, again, as I said, either personal or through observation or accompanying a principal and what you've seen, or even if you just got some indication of what you would like to achieve, even if you haven't had any practical experience, but you have an idea as to what you would like. If there's something that you've come across that you would like us to at least cover in some way, then you can bring that to my attention. Now would be a good time so that I can start making, because I'm making notes as I'm talking to candidates as to some of the things that I need to make sure in the 2 days that we will spend together that I cover.
Hi, Prof.
Yes, hi there. Who am I speaking to?
Hi, my name is Claudia.
Claudia. Claudia.
Sorry.
Oh. With which firm are you?
I'm with STBB, and we don't do any criminal law. So I might be speaking for quite a number of students when I say that we have no experience at all besides what we learned in university.
Yes.
I've been fortunate enough to shadow some advocates on an inquest, which is not really a criminal procedure necessarily.
No, it actually is. I mean, it's a very important part, and we don't actually, unfortunately, I don't want to interrupt you, but actually, what you observed there is a very important part of the criminal process that people don't actually speak much about. It's the inquest part. And for those who don't know, maybe you can explain to us what exactly an inquest is from what you've observed. What is an inquest?
Well, if I understand it, when a person dies of non-natural causes, there will naturally be an investigation into the death of the person, and then it will either be ruled to be a crime, or there will have to be some further investigation. And in some cases, that procedure can be elevated if it's in the public interest to a pretty formal proceeding, as was heard in the High Court.
Yes. So the most recent high-profile inquest was the Amotimol inquest that was recently held out, I think, in Gauteng, where he died in custody, as you say, under suspicious or non-natural circumstances. And all these many 30 or 40 odd years later, an inquest was held, and it was presided over in that case by a judge, and in other matters in the lower courts it can be a magistrate as well, who then presides in order to make a factual finding as to whether the deceased had passed away in circumstances which requires either a prosecution of an identified person or persons, or whether a finding is made that the person died from causes that need not lead to a criminal prosecution. And so it is a very important part, a preparatory part in many cases of a criminal investigation. And a lot of and you would have heard from Thamsanqa, dealing with investigating officers. And so a lot of what criminal trials relate to, they are the product of an investigation. And these investigations often take the form of a police officer or an investigating officer investigating a certain crime. But at other times, the investigation can take the form of a judicial officer participating in that process and having to make certain factual findings. And that process also takes the form of, and you mentioned, an advocate or advocates that would have participated in that process. So I take it that, Claudia, that you would have observed the advocates doing examinations, cross-examinations, and examinations in chief?
That is correct, yes.
And what exactly did you take away? What is your takeaway from that, insofar as skills, insofar as what you would need to do in order to try and get to that level of where the advocate, whoever the advocate was in that particular matter?
I was very, very impressed with the two advocates in the matter, because it was a very technical, or it involved a lot of expert technical evidence. And the advocates had to grapple with this and basically study up some engineering knowledge in the course of a week to be able to communicate and cross-examine effectively. And I also noticed how much effort went into doing this cross-examination to relate it so that the judge could keep up with how technical the evidence was.
And what that will tell you, what that tells us, is a very important part of trial preparation. I know Celeste mentioned it earlier, and Shalita as well, about trial and skills and techniques, litigation skills and techniques. And what you mentioned now about the competence of the person or persons who are presenting, much of that comes from preparation. Much of that comes from reading a file and reading it properly and knowing how to read a file, what to focus on, and then develop a trial strategy. Now that is something that unfortunately we can't teach. Trial strategy and a criminal trial strategy, and I suppose it works for civil trial also. For those of you who have civil trial experience, you need to have a strategy. And if you watch the Oscar Pistorius trial, if you have had the experience of watching the O.J. Simpson trial and some of the other high-profile trials that and that have been screened, a lot of it is about strategy. And so that is one of the things that when you are preparing for a trial, for a bail application, as we've had Thamsanqa having bail application experience, you need to understand the evidence that's in the state file, and you will have access to that file. At some point, you will, for a trial purpose, you would have had received your copies of the contents of the state prosecutor's file. It's no longer a case that you're not entitled to accessing the prosecutor's file. He can't claim that his file is privileged. You're entitled to copies of all the statements. And from reading the state prosecutors, from reading the affidavits in the prosecutor's file that he will make available to you, you develop a strategy, an overall trial strategy as to what your overall approach is going to be, and then narrow it down per witness. You're going to have to know what it is that you want to ask a particular witness. You need to know what the outcome is that you seek from a particular witness in order to know that you've been effective as either an examiner-in-chief or as a cross-examiner. And this requires thorough preparation, but also some skills, and this develops over time. And so when we do the practicals in the contact session, much of what we are talking about now, about strategy, you're going to need to make these mental notes. You're going to need to understand what it is when you're consulting with a particular client, with a particular witness, with an investigating officer, if you for the state, because some of you might end up prosecuting, some of you might end up being attorneys, advocates. So you need to know from what angle you're coming from and then strategize accordingly. And so this becomes very important, is to know the file, to know how to read a criminal file, to understand what a J88 is. And SAP 69 will go through some of these things. To actually know how to read a chart sheet becomes so important, so that you know what information to take from the most basic of documents that you're going to find in a file. And some of these terms becomes important in a civil matter. If, for example, out of a criminal trial, there is a civil lawsuit lodged by an accused who was prosecuted maliciously or was wrongfully arrested and detained. You, in a civil matter, Claudia works for SDBB and others at similar firms, you will get in that civil file, you're likely to get your charge sheet that your client that related to his charge in court or his arrest and the docket that was in the possession of the state. So what we are dealing with and what we are trying to deal with in these two sessions is not only relevant in the context of criminal law, you must see it in the broader context of litigation and the potential that out of a prosecution you can actually have a civil suit. And some of you might have come across that. Some of you might actually have experience of working in a firm or working on a matter which stemmed from an unlawful criminal prosecution or from some or other wrongful act that was perpetrated by a police officer. Now, I know that I've adjudicated a number of civil matters where the state, where the Minister of Police was sued for wrongful prosecution, for wrongful arrest and detention. Has anybody perhaps even had that experience in the short time and that you've been in practice? Let's see. Claudia, thanks very much. Let's see what the level of experience is. It's not even 9:30 yet. I'm just trying to get a sense of, through engaging with you, some of your experience, and in the course of that, also explaining some of the important things that you need to know. One does not necessarily have to teach things formally. Through just discussion, you will pick up a number of things in a more informal way, and I'm sure that I'm hoping that your takeaway of that is going to be beneficial for you.
Good morning, Mr. Professor Musa.
Good morning. Who am I speaking to?
I'm Adele. I'm from an attorney firm in a small rural town, 300 kilometers from Cape Town. I have the privilege, or the unfortunate privilege, to article in my husband's firm. So that is quite some days a hairy situation. My husband, the practice.
But you haven't, Adele. But you haven't told us which town this is. Is it in the north, in the south, in the east of Cape Town? I'm not sure where this town is in the rural part.
It's 300 kilometers on the N7 from Cape Town. The town is Vredendal.
Vredendal, okay.
So we're actually very Afrikaans. So this is quite a leap for us. Okay, so my husband's firm, because we are in a rural town, it's just like a general GP. You have to know everything of all that is there to know.
Yeah.
So client base is very large in respect of all the subjects of law that we have to practice on a daily basis. But my husband is excellent in criminal court. So we have not, as candidate attorneys, have a lot of experience doing the job ourselves. But my husband does take us a lot with him to observe. I did some postponements. We helped drafting him with the police. But my other candidate attorney, who's also in this group today, she is actually in court at the moment because of our schedules. We got quite short notice of this classes.
Yes.
So she's just handling some postponements in court right now. But she is actually the person who has a knack for the criminal court. I'm more of a administrative creature of sorts. And that's what I wanted to just commence with what you said about your trial strategy. I think there's like two sorts of attorneys. Some attorneys are more criminal court fabric, and some are more like the STTB clan, are more like the transport, conveyancing, and administrative type. It's sort of, if you say to someone, I'm a runner, then they ask you, did you do the comrades? Not all good runners are doing the comrades. And I think that is like being an attorney. When you say I'm an attorney, they want to know, but what are you doing in court? And I think there's also a lot of work going into cases not going to court or not a criminal case. But that is a debate, I think, for another day, that I think there is two types of attorneys, and that is where criminal is a very limited subject to the whole group.
And I have to agree to a large extent with everything and that you have said, except for one part. You seem to suggest that a person who is not necessarily interested in criminal court, that the person who is more interested in admin and those things, that there's not much pay or not much room for that person. And perhaps that is not necessarily true. I think that if you listen to Claudia, Claudia was talking about an inquest where she accompanied, as I would imagine, as the candidate attorney at STBB, and accompanied the advocate that was representing their client. There is a lot that can be done behind the scenes in criminal work. In that space, often with some of the bigger firms, particularly, who will brief counsel. But you will no doubt know that the attorneys would do quite a lot of the legwork, quite a lot of the preparation work, some of the research work. And so if you're one of those persons who, in your case, with your husband being the expert in the trial, in the criminal trials, but I'm sure that if you are not inclined to the criminal court, and you're more inclined with admin and paperwork, there's a lot that needs to be prepared. A lot of research, a lot of investigation, discussion or meetings, consultations with witnesses, and then strategizing, coming up with a trial strategy that doesn't necessarily require the person to be in court, but if you are very good at that, very good at thinking around how to solve problems, thinking around how you can read a file and advise and guide, whether it's your husband or some counsel or something, there is a place for everyone in the criminal sphere. It's not only a sphere for people who want to go to criminal court and want to go and argue a case. A lot of it, I know that I think it's Sangha, who is with Legal Aid, who has experience, and I'm not sure it was Shalita from one of the towns here up north, where a lot of pleas are being done, a lot of discussions or negotiations are being done, matters are being referred, out of court settlements are being done. That doesn't necessarily require a person to be in criminal court, but if you are good at negotiation, good at trying to persuade the prosecutor that the matter should actually be mediated between parties out of court, you can have not a big criminal practice, but you can have criminal work without necessarily spending a day in criminal court, but simply by discussion, engagement, and trying to persuade and using those skills. If it gets to a criminal trial, I suppose you can pass it on to counsel or your husband and so forth. So I wouldn't like people to leave this course or the session thinking that, criminal work is not for me because I don't want to go into criminal court. There's quite a bit that you can do. I know there's a lot of people who are, fearful perhaps, or just don't want that environment, just don't want to be in that environment. But there's a lot that you can do, particularly if you're briefing counsel there's a lot that you can do to assist your client in getting his case heard competently and presented in a manner that is competent and well prepared in order to achieve a success. But Adele, so I'm hoping that after today, at least you'll give your husband and what he's doing in a bit of a different thought, that you can probably in time to come play a bigger role in his practice if you're going to go into practice with your husband. There's a lot of support that you can give with administration, preparation of documentation, and you never know, maybe you actually do a criminal trial or part of a criminal trial at some stage.
Thank you, Prof. Musa. I do agree with you. I think when you're on criminal practice, you have to think on your feet. And I think with an administrative background, you want all the answers in your hand and you don't want to be caught off guard. And that's why I think the administrative persons are just sort of not more prepared. We do help with the criminal prep for the files, but
Yeah.
I think I lack the confidence.
Okay. Adele, I think if you can just, I'm not sure why there's a lot of background noise coming through from you. So if you can maybe just
Chelsea Daniels, your mic is on.
Sorry.
Thanks, Chelsea. Thanks, Adele, for your contribution. Who is next?
Morning, Prof. Musa.
Good morning. Who am I speaking to?
So I'm Martine Renier. So I'm from the UWC Law Clinic.
Yes, please.
Yeah, so this is I'm doing module 1 now, but I've actually done module 2 before this last year, because I started my articles in mid-year. I started in June.
Okay.
Yeah, but well, I'm assigned to Fazeka Criminal Court. That's in Guguletu.
Yes.
And my comments are mostly stemming from what Adele said. I'm very good at my admin, and criminal court has a lot of admin. I mean, we've got, obviously, we need to, because we're in a community court, we need to make our own copies of the dockets. We need to produce the files ourselves. We need to draft our pleas ourselves. And obviously, because we are a UWC, well, because we're the law clinic, we don't, for example, have paralegals or receptionist secretaries helping us with things like that. You do everything on your own. So there's a lot of admin that goes into that. And when Adele ended off, she said that she just lacks the confidence. I will admit, at first, the same with me, but I've been there nearly 9 or 10 months already. So it definitely built my confidence quite a bit. But I don't particularly enjoy criminal court. I prefer my civil matters, and the admin part also. I'm so good at my admin. We've got stats we need to keep up with, and my admin is great. And then when I go into criminal court, every day you still feel a bit nervous, even though it's been quite a number of months. The nerves doesn't quite settle. So I guess criminal court just isn't for everyone. The appearances per se is just not for everyone. But yeah, there's also been matters that I have enjoyed, because you also do see clients that you can see they're really sincere and they've been falsely accused, and it makes you sort of more driven to defend this matter. And I suppose that's also where the confidence builds then, is when you're so much more driven, so you push yourself to be able to do it. So yeah, like you said, there is really a place for everyone in criminal court.
What is it about criminal courts? Maybe you can share that with us. I mean, we're talking about the practical part of it.
Yeah.
And a lot of people are going to leave articles or leave these sessions and go back to criminal court or have an experience there. Maybe you can share with them, and maybe they can benefit from this experience, this shared experience that you've had, Adele and others. What is it about criminal court itself that you find is either unappealing or problematic?
Well, for me, the first few cases I've dealt with were quite straightforward: theft, assault common. So most of them pleaded guilty. It was very straightforward. But then, as obviously as time went on, the cases remained the same. For example, assault common, theft, possession of stolen property. But then I would see their criminal backgrounds, and that scared me quite a bit, because a lot of the accused have criminal backgrounds of rape and murder, and it's like, it's not just once or twice, it is 14, 15 previous convictions that they've had. So that is, I don't enjoy working with well, accused that have that sort of background, and many of them still pending trials, but many of them also already convicted. And I think as a woman in South Africa today, that is my biggest fear. So I don't enjoy representing someone that was capable of doing something like that. That's just personal, that has been my biggest fear. And I have had an experience in criminal court where I represented a client on an assault matter, and he kept coming to court every single day, and he had no business there. He was not on the roll, and I had to have a police officer accompany me anywhere I needed to go, because he would wait by my car. So I guess that's just, it's more the personal fear that has prevented me from really enjoying my experience at criminal court.
You know, Martin, thanks for sharing that. You know, I mean, nobody can deny, you know, in legal practice at the moment, it is quite dangerous. We've seen what has happened to several of our colleagues over the past number of years. People being gunned down, attorneys being gunned down, advocates being gunned down in front of the children's school. We've seen attempted murders on some attorneys who have thankfully escaped.
Yeah.
And charges are still pending. I mean, we understand, we've heard, I think it was Celeste who spoke about the fact that she's gone down into the cells and consulted with clients in criminal court. So nobody can dispute, and nobody, I think, will dispute that there is an element of criminal practice that, you know, unfortunately does carry a bit of risk, and nobody can fault anyone for steering clear or trying to steer clear of criminal practice if that is a fear which you actually have. It's one that one has to live with, no matter how senior you are in practice. We've seen recently allegations being made that even judges are not immune from being targeted. I mean, I worked at Wynberg, and I know that one of the magistrates there was gunned down in his driveway some years ago by accused or persons that were in a gang that he was adjudicating. So there is quite a bit of risk. It's not only for attorneys, it's not only for magistrates, not only for judges, for prosecutors, even police officers. So in this space, in the criminal investigation, prosecution, criminal trial, in this entire sphere, there is risk. And I don't think anyone should go into this part of practice and close your eyes to it. You need to always be wary of this, even if you are wanting, even if you are prepared to do this work. You must be mindful at all times that there is a measure of risk involved. That is just part of the practical realities that, as Martin says, that we are in fact living with. If you can handle this, if you can manage it, then I think that Martine has mentioned something that is important that we learn from criminal practice, and that is that it is the part of the law that doesn't change much. If you do it often enough, it actually becomes a lot easier. Yes, the fear that is there will probably stay with you. But in my experience, in a criminal law as such, criminal practice is much easier than civil practice. Because civil practice is so broad and so deep and requires so much more knowledge and skills. Insofar as the laws are concerned, criminal practice, you can run a fairly good criminal practice and the processes are very much the same. The principles remain the same. Statutory amendments there are, but by and large, you can run a good, successful practice by just doing the same thing over and over. You just get better at it. And as with anything, with civil work as well, the more you do, the better you will become. But the question that I want to ask you, Martine, it's about support. So how much of support do you have from colleagues in court, maybe not even at the firm where you're at, but from colleagues? Are you able to ask prosecutors? Are you able to ask other attorneys for guidance and advice on aspects that you feel that you're a bit out of your depth?
Yes, no, most definitely. So initially, when I started in criminal court, I obviously treated the prosecutor as my enemy. And then at one point, she told me, you know, we're going to work together for more than a year, so we should probably get used to one another. And after that, we started working on cases together, if I can put it that way. And not obviously, I mean, she's still the prosecutor, I'm still the defense attorney, but we were working in the best interest of all parties. And I definitely do have support in court. Like I said, I am based there, so I've gotten to know the clerks of the court, the interpreters, the magistrate as well. It's always the same magistrate in that court. So I definitely have support, and I've seen it mainly when I had this accused follow me around, etc., or appear in court. It was actually the interpreter that informed me that on a day that I was not there, this accused was there again. And so yes, I definitely do have support from the staff in court, and also actually in the office as well, because obviously I had to inform my supervisor, because, well, I told her that I'm so fearful of going back. And yeah, they've really been a big support. So criminal court is not all that bad. I mean, you are going to run into your cases, and what I do have to say is, because I don't want criminal court to sound like it's the worst thing on earth, but I mean, even when we go to civil court, you're going to run into characters, if I can put it that way, that are going to scare you, and it can happen anywhere. It's not like it can only happen in criminal court. It can happen anywhere. But I guess just working one-on-one with the accused, that has been fearful. But I definitely have the support at criminal court from all parties involved. I definitely do.
Okay, so one of the things that I think that is important from what you've said, that that needs to come through in a criminal court practice session such as this, is that it is something that you've learned and something that you've mentioned, and that is that when you're doing criminal court practice, you must not see the prosecutor as an attorney. If you're an attorney or candidate attorney, you must not see the prosecutor as the enemy in court. That I understand is something that you are almost taught, that it's the state versus the accused, whatever his name is.
Yeah.
And because we come with that idea that it's the state versus so-and-so, and you are acting for Mr. So-and-so, therefore it's the state versus you as well. and we need you need to, and I can say this to you, having been at criminal court, having practiced, having sat as a magistrate in criminal court, you need to understand that the prosecutor is not your enemy and neither is the magistrate. Yes, some magistrates may be difficult, but the magistrate as a judicial officer, as an officer of the court, you are also an officer of the court. The prosecutor is also an officer of the court, and that binds all of you as part of one team, but playing the game, as it were, from different sides. The magistrate is sitting up there and is having to be balanced and fair and independent and impartial and making decisions that is in the interest of justice. The prosecutor is, of course, serving a particular interest, but he's got nothing and he should have nothing personal against the accused. And if you're going to prosecute, that is something that you need to be guided by, is that it cannot be that you have in criminal practice that you've got some gripe with an accused, no matter who the accused is, no matter how long his criminal record might be. You need to treat each and every case and each and every matter. The accused is presumed innocent until his guilt has been established. And the fact that you believe in your case as a prosecutor, is important, and you must pursue the prosecution, but not to the point where you make decisions that amount to an abuse of your authority. And the best prosecutors that I have found are the ones who understand that, but simultaneously the best attorneys I have found are the ones who also understand that they are not against the prosecutors also, that they can also work with the prosecutor. And at times, if you are representing, as some of you have represented accused persons who have either admitted to you their guilt or have a long track record that is not necessarily something that appeals to you, then you need to work and be able to work with the prosecutor and try and persuade him either to go a bit lenient on your client, use your skills, your charms even, to try and make sure that you get the best possible deal for your client. In the end, that is the interest that you are serving. And it is a case where, as the Constitution says in Section 35, an accused person in a criminal matter is entitled to competent legal representation. And that requires a number of things. That competency entails a whole range of things, not only your skills as a person knowledgeable in the law, but competence also in understanding the landscape that you are working in, understanding the courtroom, understanding the magistrate, understanding the environment in a courtroom, understanding in the investigating officers and how they think, how the prosecutors think. All that is part and parcel of your competence. Also preparation. An accused is entitled to competent legal representation, and if you are his attorney, you must presume him to be innocent until the state is able to prove his guilt. Even if you suspect that he may be guilty, even if you don't like his politics, even if you don't like his look or his background is unappealing to you, he is presumed innocent. And if you accept the brief, then you take on a heavy responsibility and you must fulfill that duty as an officer of the court. You cannot allow yourself to let your personal feelings about the accused, if you've had a personal bad experience or a family member has had a bad experience that may influence the way you look at your client, the way you decide to approach his case, to try to compromise him, even if you are thinking along those lines, you need to check that. You need to check that. You need to continually ask yourself whether you are doing your client a service, whether you are fulfilling his right to competent legal representation, whether you are preparing well, whether you have read well, whether you have done as Claudia says, the advocates and that she has seen came there and that they were well prepared, well versed in the material. All of this becomes important as part of your understanding of your obligations as a criminal legal practitioner who understands what your obligations are, both as an officer of the court and as the legal representative for an accused who has various rights under Section 35 of the Constitution. And you must uphold your oath as an attorney, as an advocate, an oath that you take to uphold the Constitution. You have sworn to all of that, and therefore you must ensure that in criminal practice, your personal views cannot compromise what is uppermost and most important in that environment, and that is the right of the accused.
Yeah. Thank you so much.
Thanks. Okay, so we've gone through 6. Let's see. We'll do this for the first session. We get a sense of some experiences, and as I said, I can impart some of the introductory parts of the work that is so important as part of criminal practice, things that we can just speak about and share and learn from some of these shared experiences. And so, who's next? Yes.
It's Adele again. Sorry,
Yes,
just
Adele.
quickly. I think respect with your court officials or your other court officials in court goes a long way. But I also feel that your principle sort of paved a way for you. My husband's principle did not do him any favors in that regard. So he had to make up a lot of ground with the other court officials. And that is sort of a legacy that he wanted to leave behind for his candidate attorneys, not just because I'm his wife, but his other candidate attorneys as well, is to create an atmosphere where we as candidates can approach the prosecutors and other court officials with a sort of dignity, or not confidence, because I still feel that I lack that, but just that we know that they are there for us to help us, and that they will help us because of the principle that we have.
That is so true, and thanks for that, Adele. I certainly recall when I started out as a candidate attorney, also at the criminal defender clinic, as it then was years ago, now the legal aid, and the early years of criminal practice. One of the things that I also realized quite early on in just engaging with court staff, your court orderlies, the police officer in court who brings the accused up from the cells, the interpreters at court, the registrar or the stenographer. These are important officials, albeit administrative, clerical, or otherwise. These are important officials in a criminal court, without whom a criminal court cannot function. And as a criminal court practitioner, you need to understand at times that you will end up waiting hours in criminal court if you don't have an interpreter. You can wait for quite a while for a police officer or a court orderly rather, who does not want to take you down into the cells for you to go and consult with your client. You can wait quite a while for a stenographer who's there, but does not want to come into court to allow you in advance of the court time to listen to the recordings of the previous days or previous time proceedings. So if you maintain a good relationship with all of these officials, many of whom are low-paid officials, but have respect for the way in which they do their work, and if you respect them, that goes a long way to them feeling good about the work that they do and the role that they play in keeping the system going. And so, Adele, it's so important what you have said about giving them respect. I'm not sure, I'm getting a lot of background noise. I'm not sure whose mic is on, but if you can please
Priscilla Yankees.
that your mic is off, because it's, yeah, if you can all just switch your mics off after you've spoken so that we can all make sure that we don't get that background noise, please.
Bro,
Okay.
Bro,
Yes.
Here, can I just quickly say something?
Yes, of course.
With respect to respecting everyone's rights to a fair trial, when I was doing opposed bail applications, I had to also make that differentiation between, my personal views and fighting for what is right, or defending this person's right to a fair trial. And once you've made that separation, it becomes so much more enjoyable, because you're arguing the law, that which you've studied, and you're looking at the different elements, and then it becomes, you get, like, I was very passionate about doing that, about fighting for this person's right to a fair trial, and also respecting his rights, and arguing the law with my colleague.
And that just demonstrates, a level of maturity that we all need to strive for, in doing what we do, whether it's civil work or criminal work. It's getting ourselves to a level of maturity where you can actually, enjoy the work and that you've done or that you are doing, because you are able to practice what you have studied in an environment that you are comfortable, but also in a way that you believe that you are fulfilling either your oath of office or your duties under the Constitution, or both. And if you're feeling that you are able to advance the rights of an accused person in criminal court, if you're in criminal practice, there's no better feeling than that if you're a legal practitioner. Of course, if you're the prosecutor and you've managed to secure a conviction, and you've managed to secure the kind of sentence that serves the interest of the public, again, there too is no better feeling than that, than you've done, your job, you've gotten a criminal off of the street. And again, as a judicial officer, when you feel that you've been fair and impartial, you've been balanced, and that the outcome is one that is just, again, there's no better feeling than that when you are on the bench. And so it's all about getting job satisfaction. And that's all part of understanding what your role is, and it's understanding what your role is then as a criminal legal practitioner, and understanding the rights of your client, but at the same time understanding your own obligations. And one of the things that we'll talk about after tea is about the ethical obligations that you actually have. We've touched on some of it, but in criminal practice, there is quite a bit of ethics that is involved that we need to know and understand, because in a criminal practice, if you're not guided by ethics, you could end up not applying the law properly, because you're clouding your judgment and you're clouding the work and that you're actually doing. But I see it's only 10:05. We'll carry on till about 15:15, and maybe there's a few others that are waiting to join and share with us some of their. Yes.
It's Shalita again, sorry. I just have a comment with regards to the statement that we should not see the prosecutor as the enemy.
Yes.
And I understand that, but it's quite problematic. I'm not sure if it's only in rural areas like where I'm from, or in a lot of the courts, but especially at our court, some of the court officials doesn't realize that the magistrate court, so they are creatures of statute and has to follow procedure.
Yes.
And they have a way of doing or following their own procedure, irrespective of whether they have that inherent jurisdiction or not. And it's quite frustrating and difficult at times trying to make the prosecutor understand, but this is what the law says, this is what the procedure says, and you have to follow it this way, and they can get quite arrogant about that. And for instance, I had a case where the co-accused explained a few times to the prosecutor that my client, which was his co-accused, is the wrong person because they referred to him on his nickname, and he was the wrong Smiley at that time, and he wasn't the person who committed the crime with the co-accused. And the prosecutor just didn't want to hear anything about that, irrespective of us doing the affidavits. It was necessary, so it's difficult to not see them as the enemy.
I think that when we spoke about not seeing them as the enemy, I think that you must understand that perhaps actually different to what you are talking about. So what you seem to be talking about is a prosecutor or prosecutors, if there's more than one, who understand their job and their function differently to what the norm should be. It seems like some of the prosecutors in your instance were not able to differentiate almost right from wrong, and that you were struggling to try and persuade them to see that what they are doing, that the accused that they are charging or how they're dealing or treating them is not right. I don't profess that all prosecutors are somehow angels. I don't profess that all prosecutors are good at what they are supposed to do. But what I do say is that prosecutors, like attorneys and magistrates, we all have to aspire to doing and understanding our respective jobs and doing it in a way that conforms with the norms and standards of that particular part of the criminal justice profession that we are part of. Either we're part of the prosecuting branch or the legal profession, the attorneys or advocates profession, or the magistracy or judiciary at large. And there are norms and standards for all of them, and we need to abide by those. We need to understand what they are and then enforce them. And if those prosecutors that you are talking about, if they failed in their duty to apply the norms that they should enforce, it gives them a bad name, because your impression of them is then negative. Your impression of them is that they are the enemy. And all that means is that they have failed in trying to work in conjunction with the attorneys or legal profession. And it may very well be that this is something that happens in small towns where everybody is so close-knit, the communities are small. It may be different in the bigger cities. I know that in the small towns, prosecutors are often referred to as the ondermagistraat. The accused often see the prosecutors as just some kind of magistrate at a different lower level, because the magistrate and the prosecutors are often seen talking, being almost like a close-knit group. And so the prosecutor is at times referred to as the ondermagistraat. But that kind of impression of what role they have or who they are, the prosecutors and the prosecutorial branch need to ensure that they try to work harder to ensure that they rid themselves of those terms, because it does not give rise, or it continues this impression of them that they are biased, that they're only one track, they're narrow-minded, only looking after one party's interest, and that's the state and the public. But I think that it was it was Martina, I think, who said that she's had a different experience where she was able to work with the prosecutors almost as a team. So her experience, Shalita, is certainly different to what yours has been, and maybe that is something that needs to be nurtured and inculcated in prosecutors around the Western Cape and in the small towns, rural areas, where if it's not being done, then this is something that should be a culture that we need to try and change. Who else is there that wants to share with us something before we break for our tea? Anyone? Okay, well, let's break there. Let's resume at 10:30. I think that's been quite informative. People sharing their experiences, and in doing that, we did some of the introductory things that is needed, that we would have needed to actually do before we start on some of the more formal parts of the work. And when we come back, we'll touch on ethics in legal practice and consultation, and then we'll proceed from there. Okay. We'll resume at 10:30.
Thank you.
Thank you.
Thank you. Okay, we are back. It's 10:30. So I'll proceed. Are we all, can you all hear me?
Yes.
Okay.
Yes, sir.
Yes.
All right. So, as I said
Yes,
before the
Professor.
break, thank you. As I said before the break, what we'll do is we'll start and have a chat. We have already started to discuss aspects of ethics in criminal practice. And that's one of the important parts of, from a practical point of view, in criminal practice, as with any part of legal practice, it's an important part, namely dealing with ethics. And in the last maybe 2 weeks or so, you would have seen in court attorneys, in one instance an advocate, conducting himself or themselves in a manner that appears to be wholly unbecoming of a legal practitioner. I was just reading in the break a report that the one advocate has now been suspended by an order of the High Court in Limpopo as a result of the fact that he, during the course of a hearing, referred to, called the judge stupid. And you might have seen in the last few days on the internet the outbursts by an attorney appearing in Johannesburg in an online hearing and swearing at a judge and uttering all sorts of foul language. And so the question of ethics in practice is once again in the spotlight, in not just civil practice, but also criminal practice and practice in general. And so this is clearly a part of practice that is of concern to the Legal Practice Council, the judiciary, and the legal profession in general, that practitioners need to understand what their responsibility is, not just from a legal point of view, but from an ethics perspective. And so when we're dealing with ethics in criminal practice, there's a number of aspects of criminal court that we must deal with before we get into, the ethics involved during a hearing. So there's other parts of ethics that is important also. And there is, as one of the colleagues spoke about earlier, I think it was Adele and Shalita, who spoke about respect. So respect is an important part of ethics in any practice, not only criminal practice, but civil practice. And so there is respect not only for court officials, but there's also respect for people's time. And so in criminal practice particularly, courts ordinarily start at 9 o'clock. And so part of your ethical rules and ethical standards must certainly be to ensure that you are punctual for a hearing. If it is due to start, if you are due to be in court at 9 o'clock, then your rules of ethics require that you must either be there at the designated time, or if not possible, then arrange in advance that either somebody stands in for you, or alternatively, that you contact the prosecutor, alternatively, usually, more importantly, the presiding officer, and just explain and request that you be excused. And you can either do that through a telephone call if it's possible, alternatively appearing in the magistrate's chambers early in the morning, explaining and asking that you be excused up for a certain period and that you undertake to be back at a particular time. So that is a critical part of criminal practice, and that is respect and showing respect to the judicial officers. But also another part of that respect, and I know that Shalita's had a different experience, but there's also, as I think Martin was more on point, and that there needs to be respect also to the other court staff, and that is the prosecutors and the court orderlies and other staff that are part of the criminal justice system that makes a courtroom function. A courtroom does not only function because there's a prosecutor, it also functions because there's a judicial officer, there's a stenographer, there's an interpreter, and there's a court orderly. These are key role players in making a court function, and they are all part of the court staff, and they are all entitled to respect. And so as a practitioner, whether it be a candidate attorney practicing or as a principal attorney, you have a duty to ensure that you uphold these ethical standards. But it then goes further than just that, and that is the slide that then I've got on there. And then it comes to something that we sort of touched on earlier on, and I think it was also Martin who mentioned that there is this tension between your own sense of right versus the interests of the client that you are required to serve. So it will happen in a course of a criminal matter that you take instructions from your client, and we've heard from Thamsanqa where he's taken instructions from clients and done various pleas, guilty pleas. But it will happen, or it may happen, that a client gives you an instruction and explains to you his guilt and explains to you exactly how the events unfolded that led to the crime. You then prepare the plea, the guilty plea, and you come to court and you present it to the prosecutor, and either the prosecutor does not accept it, or alternatively, the magistrate, after you've read it, the magistrate then indicates to you that the magistrate is not satisfied that the accused has pleaded to all the elements of the crime, and that the magistrate is not prepared to accept the guilty plea for purposes of section 112. You then, in these circumstances, are faced with the situation of either amending your plea so that you can rectify and address the shortcomings that the magistrate has pointed out, which requires you to make further admissions or present further statements in the affidavit or the statement that ensures that the plea reflects an admission of all the elements of the crime. But then say that you don't end up with a plea that satisfies the presiding officer. Or, as sometimes happens, although quite rarely, but the rules provide, the statute provides for it, is that your client pleaded not guilty or pleaded guilty, and a plea is changed to one of not guilty at some stage. And a trial then pursues, or ensues rather, and witnesses are then led. The question that now comes in, what are some of the ethical conventions, ethical rules that you need to ensure that you uphold when you present your client's case? Now, one of the critical rules that you are now faced with is you now know from your client's instructions, you know that your client has admitted to his guilt. But now a trial takes place and you've got to cross-examine witnesses, state witnesses. how do you present your client's case? How do you cross-examine a state witness and put a version to the state witness that deals with your client's case, because now your client is before the court and the plea is one of not guilty. Either the magistrate has changed the plea from guilty to not guilty, and you now have to run the trial. How do you present your client's case in such a way that you do not present a version to the witness that you know to be false? Because even though the magistrate has not accepted the guilty plea, that does not change the fact that your client has admitted to you that he did the deed. He shot the deceased. He stole the bread, assaulted whomsoever, and that he did so willingly, he did so intentionally, and with knowledge of unlawfulness. You know, you've satisfied yourself. It's just that the magistrate is not satisfied as to your client's admission of all the elements. But that does not mean that the knowledge that you gain is all of a sudden becomes null and void. So how do you then go about preparing a cross-examination for state witnesses in a manner that on the one hand presents your client's case competently? The case that you must now present is the one that then deals with those elements that the magistrate was not satisfied with as having been admitted to. You now have some sort of leeway to try and ensure that perhaps you deal with those elements in cross-examination and prove that the state is unable to prove those particular elements. Because remember that the burden of proof in a criminal trial is on the state. The state must prove all the elements of the crime and your client's guilt therefore beyond reasonable doubt. Not on the balance of probability standard, but beyond a reasonable doubt. And as you would have known from your studies in criminal law, that every crime has certain elements. And the state must prove each of the elements. And if the magistrate has not accepted a guilty plea, it is usually because one or more of the elements were not met. So when you are in criminal court and you are faced with that type of scenario, one of the first things that you would need to ask yourself is, which element or elements is it that the magistrate was not satisfied with? You need to note that down. Because if you're going to change the plea and add new facts or additional facts to deal with specific elements, you need to know which elements it is that you need to improve on in the plea to ensure that you satisfy the magistrate that all the elements have been met. But if a trial ensues, knowing which elements the magistrate was not satisfied with has been met, you then have the opportunity of using those elements and attacking the state's case in relation to those elements that the magistrate is not yet satisfied has been proved or has been admitted to. That means that there is evidence that the state would need to present in relation to those elements, particularly to persuade the magistrate that the accused is guilty. You can then challenge those parts of the elements of the case. But in doing so, you need to ensure that in the preparation of your cross-examination, that you ensure that when you're putting your client's version to a witness, that you don't put a version that you know to be false or untrue. And that means that you need to understand your client's instructions, the facts that the client gave to you. You need to understand that very carefully. And you need to bear in mind that one of the techniques of litigation in a criminal court, as with a civil court, one of the important techniques in cross-examination, and you will do some of this when we do the mock trials, one of the important techniques is you need to ensure that you not only cross-examine the witness on facts that he or she has testified to, but you need to ensure that you also put your client's case to the witness. And the way you basically you would do that in a criminal course of a criminal trial is along the following lines. So let's say you're dealing with an assault charge. Your client is accused of having assaulted a certain named female person and is alleged to have assaulted the person using a brick, hitting the person on the head. So an assault with intent to do grievous bodily harm to the person. And it is alleged that the crime took place at a certain venue at a particular time. All of that would be in a charge sheet. And your client would have pleaded guilty, or you would have tried to plead guilty on behalf of the client, and you would have admitted some of the facts. But perhaps the court wasn't satisfied that your client had the necessary knowledge of the unlawfulness of his actions. Let's use an extreme example. Now, if your client has admitted to you that he was at the particular place at the particular time in the charge sheet, maybe it was the 1st of January 2020 at Cape Town. If he's admitted to you in consultation that he was there and he was in the presence of certain people who were there, when you put your client's version to the witness, you can't then deny to any of the state witnesses, you can't deny that your client was at Cape Town on the 1st of January 2020 at the particular venue where he has admitted that and that he was. Because if you then put to the witness that my client will deny when he testifies that he was at Cape Town on the 1st of January 2020 and that he denies that he could have committed the crime, that would be a false version because it clearly contradicts the evidence that your client will testify to when he is in the witness box. Because if your client has admitted to you that he was there at the particular place as per the charge sheet, he can't later testify that he wasn't there. You cannot then permit your client to testify that he wasn't there if he's admitted to you in consultation that he was there. Because that would then, if your client testifies falsely and you allow him to, you would be participating in leading evidence before a court that you know to be false. Your client would be perjuring himself in that he would be testifying to facts under oath while knowing it to be false. Not only would your client then be exposing himself to the risk of a charge of perjury in addition to whatever charge he is facing, but as a practitioner, you would then expose yourself to the risk that you could be charged at the very least for an ethical violation in that you as an officer of the court allowed your client to testify to facts that you knew to be false. And remember that when you are leading your client's evidence, although you are not the person testifying, you are actually, when you're presenting your examination in chief, you are placing these facts before the court. And as an officer of the court, you have a duty to ensure that you are placing facts before the court through the mouth of your witnesses, only facts that you are comfortable that is reasonably possibly true. And so once your client has admitted to certain facts, it becomes very important that when you're preparing your cross-examination and when you're preparing your examination in chief, that you must fully and properly understand what these admissions of facts are. It is important that you always, as part of criminal practice, that you understand what these factual admissions are. And a good practice to follow would be that in consultation, as your client is admitting, making certain admissions, in as much as you would, when you're preparing, as many of you I think would have experience in preparing a plea in a civil matter, one of the things that you do in a civil plea is you admit to certain things that have been alleged in a particular claim. Now, in a criminal court, you must see the comparison between a charge sheet in a criminal court and a particular claim in a civil court. They serve a similar purpose. In a particular claim, the plaintiff basically sets out the allegations of fact that forms the basic premise for the claim that he is making and the relief that he seeks. In a criminal court, the charge sheet serves that purpose. There are various allegations of fact that the prosecutor makes against an accused person, and the ultimate conclusion of that, or the relief sought, is that the person be found guilty of having committed the crime alleged in the charge sheet. And in as much as a defendant in a civil matter will file a plea in which he will admit certain allegations in the particulars of claim and may deny others. Similarly, when you're preparing for a criminal trial, you will do likewise. As the legal practitioner, when you're consulting with your client, you will follow a similar process as you would for a civil matter. You would similarly make notes of those allegations in the charge sheet that your client is admitting to, and you would make sure that you make notes of those allegations in the charge sheet that your client denies. And that is why one of the important techniques in criminal practice is, before you prepare a plea for a client with the admissions that you are wanting to make, one of the important techniques is that you need to ensure that by the time you consult for purposes of plea preparation, that you are in possession of the charge sheet, that you are in possession of all the statements in the prosecutor's file, and that you have studied the charge sheet and the various statements. Because when you are preparing a plea, or before you prepare a plea, you will have to consult. And one of the things that you must deal with in consultation for plea preparation, and that's for trial preparation, is you need to put to your client the version that is in the prosecutor's file. And you need to get from your client his or her version to the allegations made in the charge sheet. And this is how you elicit from your client, this is how you get from your client the admissions that he is making, the facts that he is prepared to admit to, that is contained in the charge sheet, very much the same as you would in a civil matter get your client to indicate whether he admits to certain allegations of fact contained in the particulars of claim. And so one of the important skills that you as a candidate attorney and aspirant practitioner need to develop, particularly in criminal practice, is to be able to take a charge sheet. Take the charge sheet, and where the allegations are made about the specific charges, break the crime down into the different factual elements. And by that I mean is, if the charge sheet would read something along the lines of, on the 1st of January, it will be addressed to the accused. The charge against Joe Soap, it is alleged that on or about the 1st of January 2020 and at or near Nando's in the district of Cape Town, you wrongfully and unlawfully you wrongfully and unlawfully hit Amanda Matthews with a brick over her head with the intent to thereby do grievous bodily harm to her. Now, something along those lines that the charge sheet would then read, something along those lines. You would then need to break.
Sir,
Yes.
sorry, I just have a question. If you I job shadowed William Booth on
Yes.
a case a few years ago, but if your client either in consultation tells you that they're guilty or says they're not guilty, but you can infer from their behavior that they are,
Yes.
then how do you represent that in court?
Okay. All right. So this is exactly some of the what we are dealing with, some of the ethics. So let me just ask you, when you say how do you represent that in court, are you asking how do you present that insofar as the plea is concerned, or how do you present that insofar as cross-examination or examination in chief? What exactly are you referring to? Or are you asking me, do I tell the magistrate that my client has admitted his guilt? What exactly is it that you are asking me to clarify about how you approach that in court?
Yeah, like how you would further the pleadings or make the pleadings, and yeah.
Okay, no, fine. Okay, so this is something that happens almost daily in criminal practice, as you will consult with a client with the charge sheets and the pleadings, the affidavits and statements and so forth, and either the client will tell you, or as has been mentioned, from the conduct you might infer guilt of some sort. Now, we need to separate speculation from fact. So if the client doesn't say to you, I did the deed, whatever the deed might be, if he doesn't admit a specific fact that is alleged, if you suspect guilt on his part, that suspicion on your part is nothing other than speculation. You must remember, and I've mentioned it earlier, that one of the fundamental rights of every accused is the right that he has, that it is presumed that he is innocent until his guilt has been proved beyond reasonable doubt in a court of law. As his attorney, if you suspect he is guilty, that is nothing but your speculation, and you cannot act on that speculation. You must respect your client's right, his fundamental right of presumption of innocence. And so there is no obligation at all on you to either inform the court that you suspect he is guilty, nor is it wrong for you in cross-examining a witness to put to the witness that my client will testify that he is innocent of the charge. Under those circumstances where it is merely your suspicion that your client is guilty without him overtly admitting his guilt, there would be no ethical violation on you if in your cross-examination of a witness, or if in your examination in chief, you're placing evidence before the court and that he is innocent. But it is a different story when your client has expressly told you he is guilty of the offense. Now, again, here we need to be very careful. Merely because a client says to you, I am guilty, doesn't necessarily mean he is guilty of the crime of which he is being charged. Often what you find, accused persons will come to court and they will say, and I mean I've often had it when I was presiding on the bench, an accused will say, "Agbare, ek is skuldig met 'n rede." You know, they often, accused will come to court and they will tell you they're guilty, but that there's a reason why they did this. And often the reason that they have is something that indicates or suggests that one or more of the elements has not been met with. And the same then, you need to make sure that when you are in your office consulting with a client, if the client says to you, meneer, dame, ek is skuldig, you need to unpack that. Simply because they say they're guilty, they're looking at things from a layperson's perspective and not necessarily through the eyes of the law and what the law would regard as guilt or innocence. And so you need to then unpack the individual facts so that you can exercise your judgment, use your skills and the tools that you have from the trade that you have been plying here, and you can then make an assessment as to whether or not your client has admitted to sufficient facts from which a reasonable court will find that on these facts he is guilty of the charge in the charge sheet, or he is guilty of potentially a competent verdict. Because that is the other important dimension of criminal practice, in that when you are sitting with a charge sheet and your client is charged with a particular set of charges, you must never forget that in the Criminal Procedure Act, there are these so-called competent verdicts. Verdicts that even if the court were to find your client innocent of one of the charges or all of the charges in the charge sheet, it is still possible they may find your client guilty of an alternative that is mentioned not in the charge sheet, but it is mentioned in the relevant section of the Criminal Procedure Act dealing with competent verdicts. So you need to also be familiar with those competent verdicts that may be applicable in a particular case. And so when you're consulting with your client, even if your client is pleading, is saying to you, I'm innocent of a particular charge, you need to start thinking about whether on these facts he may be found guilty of a competent verdict. Because if all you are going to court is preparing on the particular charge in the charge sheet and not familiarizing yourself with the landscape that you are dealing with, and the landscape being all the possible verdicts the court may give, including the competent ones, if all you're preparing is on the narrow charges in the charge sheet, you may prove your client's innocence on those charges, but in doing so, you may very well find yourself in a situation where the court finds your client guilty of one of the competent verdicts that the court could convict him on at the end of the trial, based on certain admissions that came through in the evidence that related to competent verdicts. So when dealing with the question that is being asked, then, if when your client says to you, I am guilty, don't just accept that he's accepting guilt. He's accepting guilt in a layperson's knowledge and understanding. That is a legal finding that must be made by a court of law, but you need to make that finding yourself as the legal practitioner. You need to make that finding yourself and satisfy yourself as to his guilt based on the facts that he discloses to you in consultation, the admission that he makes in consultation, because you need to advise him at some point whether he is in fact guilty, whether he is guilty or whether he is innocent, but that he merely understands in a layperson's way he is guilty. And if you come to the conclusion that your client is actually innocent, you need to be able to find the words. You need to have that conversation with your client to explain to him in a language that he understands as simplistically as you possibly can why in law he is actually innocent and not guilty. Because remember that at some point when you get into criminal court and the charge is read out to your client, the prosecutor is going to ask, well, the magistrate rather is going to ask your client, once the charge is read, is going to ask your client, do you understand the charge as read out to you? The magistrate must ask that first. And your client must answer himself or herself. And you need to prepare your client for this. When you're preparing your client for even a guilty plea, you need to, or a not guilty plea, any plea, you need to explain to your client that the process in criminal court is that the charge will be read out by the prosecutor to your client. And you need to ask your client up front what language he is prepared to have the proceedings conducted in, and you need to make sure that the proceedings are conducted in the language of your client choice, and if that means an interpreter, well, then an interpreter is going to be needed. You also need to establish, insofar as this goes, just some important things in that consultation that you must have. One of the important things, that's part of ethics. Part of ethics involves you also respecting your client's language. And so you need to establish from your client what language he's comfortable with. And if you're not comfortable in speaking, maybe if your client is Afrikaans speaking and you English speaking, and you're more comfortable in presenting your client's case competently in English as opposed to in Afrikaans or vice versa, you need to ask your client, inquire from your client whether he is prepared to consent to you conducting the hearing in court in the language of your choice, whilst an interpreter is used to interpret to your client in the language that he is more comfortable in. Even if it's English or Afrikaans, you need to have that conversation. That's part of ethics in criminal practice. Part of respect for your clients, not only your client's rights, but also one of your client's rights is the right to have the proceedings conducted in a language that he understands. And so, if you're then presenting the case and preparing your client, you need to explain to your client that the proceeding in court will be that it will start out, the prosecutor will read the charge out, but before he reads the charge out, you must place on court, on record, what language your client speaks and what language your client is comfortable in having the proceedings conducted. Because that is then the language in which the charge must also be read out to the accused. If it's read out in a different language, it must then be interpreted for the accused in the language that he understands, because the magistrate will then ask the accused after the charge is read out in the language of his choice whether he understands it. And your client will then have to speak to the magistrate himself, and you must prepare your client in consultation for that. That is part of your duty of representing your client competently. Part of that duty is involving the ethics of practice, is preparing your client for what is going to unfold in the proceeding. It shouldn't come out as a surprise to your client as things unfold, then he's learning about this. Because often what happens is, it's not always that you have accused persons who have been in court many times. Some, yes, some less than others, and for some it's going to be the first time or second time that they're in a courtroom. And so they're unfamiliar with the surroundings, and so you need to be the guide that takes them through this in advance and gives them insight into what is likely going to happen in court. That's part of being a competent practitioner, is preparing your client for what is coming, so that your client is comfortable with the surrounding. And that involves in explaining to your client that the prosecutor is going to read out the charge. The magistrate is then going to ask you, do you understand the charge? Your client must then explain to the magistrate or answer in the affirmative if he understood, but you need to also explain to him that if there's something he didn't understand, he needs to either inform you because you will be in court and he can then speak to you or call to your attention something that he doesn't understand, or tell him that it is within his rights, if he didn't understand anything, to tell the magistrate that no, I did not understand the charge as read out to me. Because if he didn't understand it, he shouldn't be pleading to that charge. Because he could be pleading to something that he doesn't understand and pleading to it wrongly. And so this is all part of trial preparation or hearing preparation. And that is all part of being a competent practitioner. And that is all part of criminal law or criminal practice ethics. And so but for you to be able to explain that to your client, you need to know the process yourself. You can't explain that which you don't know. So you need to understand what is going to happen. And that's part of the reason why the discussion in the morning was so important, is for me to get an understanding to at what level those of you who are practicing, who are in the sphere, at what level has that experience been. And of course there are others who have less experience, but for purposes of our practicals in the second face-to-face session, you're going to need to know and understand this, because that is part of what is going to happen in the practicals. One or more of you are going to be the prosecutors in the practical moot courts. One or more of you are then going to have to read a charge sheet out that would have been prepared for an accused person. And you're going to need to then understand the process from there as it unfolds. And in those sessions, I usually then sit as the presiding magistrate, and there'll be an attorney on the other side and an accused person. We'll have some people acting as the accused person, and there will be an entire setup as you would likely have it in a courtroom. That's what we try to simulate in our face-to-face mock trial sessions. And so in the consultation that you then have preceding the trial, preceding the hearing, this is some of the things that you will talk about. But again, coming back to the issue of a client tells you that he's guilty, how do you respond? And your response at that juncture is critical. A client saying he's guilty, you need to assess and evaluate the facts. You need to unpack those facts with the client and apply your own mind to determine whether the client is guilty of either the charges as contained in the charge sheet or any of the competent verdicts. Because it is only if you are satisfied that your client is guilty of a crime under the law that you can then go ahead and prepare a guilty plea. You cannot prepare a guilty plea simply because your client has said to you, I am guilty. That is not a basis for a guilty plea. As a practitioner, you prepare a guilty plea only if you have satisfied yourself that on the evidence presented to you by your client and the admissions that he's prepared to make, that he has admitted to all the elements of the offense. But again, admissions can serve a different purpose also. Admissions that your client makes to you in consultation doesn't necessarily have to result in a guilty plea. You have section 220 of the Criminal Procedure Act, which is another important provision in the Criminal Procedure Act. It's the provision that deals with admissions made by an accused person at a trial. So what can happen is that In consultation, your client has given you these various facts that he admits to that is alleged in the charge sheet. And some of these facts that he's admitted to, if you are prepared to place these admissions before the court, well knowing and understanding that these admissions don't result in your client admitting to the offense as a whole, then nothing precludes you at the commencement of a trial, nothing precludes you from using those admissions and placing them before the court at the commencement of a trial. Because like in civil proceedings, and the reason I keep referencing the civil proceedings is because for a lot of you, civil proceedings is something that you're comfortable with and that you've done a lot of. And you will know from your civil proceedings that one of the things that one can do at the commencement of a trial in civil court is you can try to narrow some of the issues that is in the pleadings. So you can make certain additional admissions which may not have been made in the pleadings. And criminal court works exactly the same way. Section 220 is there, it's designed as a mechanism to narrow the issues at trial. So if you understand your own strategy, if you know what your strategy is, and we spoke about how important strategy is in any form of trial. If you have a certain trial strategy, and that strategy involves leading evidence or disputing only certain parts of the state's case, and that you don't dispute certain other parts because you want the magistrate or the presiding officer to see your client as being reasonable and not coming here and putting the state to the proof of all the elements. One of the trial strategies that some of the more senior counsel and attorneys use is that they make admissions up front of certain facts that relieves the prosecutor of the duty of the burden to prove those facts. But the strategy is such that those facts are not crucial as part of the defense and the defense strategy. And in that way, you can use upfront at the proceedings the admissions that your client has made in consultation, which doesn't lead to a guilty plea necessarily, but you use it as a means to narrow the trial and the duration of the trial. Again, that at times is an ethical way to conduct practice, because what you at times have are clients, particularly as some of you have pointed out, your more hardened criminals, guys who have been in the game for a long time, been in court for a long time. Often what happens, they want to delay the proceedings for as long as they possibly can. Because often what happens is they hope that either witnesses will die or memories will fade, and by delaying the trial process, they can possibly somehow get exonerated. The trial will fall away. And it happened a lot of times. And so their instructions to you at times will be, vertraag die procedure, delay, frustrate the process. Now you as an officer of the court, faced with a client who gives you that instruction, you know, he does not mind, even if he's behind bars awaiting trial, he does not mind waiting there. For some accused, I found they are comfortable behind bars. What they're not comfortable with is the guilty verdict. I've come across some accused who have been more prepared to spend a year awaiting trial than to have a guilty verdict against their name. They just want to avoid that because they understand the consequences flowing from that. So what are your ethical responsibilities? Now you're doing this consultation, your client's giving you certain admissions. You can't plead guilty because it's not tantamount to an admission of the offense, but you do understand that you can admit to some of these facts and narrow the issues and shorten the trial. Now, on the one hand, your client is entitled to a speedy trial, and shortening the trial by narrowing the issues is certainly one of the mechanisms that you have in order to give realization and effect to your client's right to a speedy trial. Because part of the competence of a legal practitioner is giving effect to the rights of an accused, and the rights of an accused include the right to a speedy trial. But what happens if you have a client who says, no, delay, frustrate? Do you do that? Do you then frustrate? Maybe some of you have some experience at this. What do you do? What is your ethical responsibility in that instance? Do you comply with that instruction, or do you do your duty and narrow the issues and proceed to trial on the narrow issues? Perhaps some of you can share your thoughts on this. I don't know, maybe Tamsanga is here, is done some trial work. Celeste, the bail application. Shalita, some please. Maybe some of you have some experience with something that you can share with us.
I once had a bail application that I needed to do.
And just tell us who is speaking?
Sorry, it's Celeste.
Okay, yes.
And then I had to do a bail application for a rape case. But my client did not want to consult. Every time I went down to the cells, he fainted. And so then we postponed for the next day, and we postponed again. But then later on, I had to like withdraw as his attorney because he just got sick. We sent him to the hospital, but we realized it was just delaying tactics. So I went up to court, and then I spoke to my principal, and they said, no, then we must just leave it and withdraw as attorney on record. And that's what we did, and we had to get an attorney.
And that is the ethical way of practicing criminal law, where you come across a client who you are satisfied at some point is deliberately frustrating the administration of justice in court. As an officer of the court, you are obliged to conduct yourself ethically, and you cannot be a party and should not be a party to any effort that is clearly aimed at frustrating the smooth, efficient, and effective administration of justice. But here's the question: if you withdraw, for those of you who have withdrawn and those who have not withdrawn, you would know or should know that when you withdraw, you can't just go to court and say, Your Worship, I am withdrawing. It's not like in civil court, where you simply file a notice of withdrawal, and in the notice of withdrawal, you put your client's last known address. And then the other party or the attorney on the side will know where to serve further pleadings. That is not how withdrawals work in criminal practice. In criminal court, if you want to withdraw, the only way to do it is you go to court. And then you can't also tell the court, I am withdrawing. The ethical way and the proper way of doing this is to apply to court for leave to allow you to withdraw. You've got to seek permission from the court to allow you to withdraw. And to do that, you need to place before the court some reason why you're applying to court to permit you to be excused from the matter. And your client must then proceed either on his way alone or with another attorney. So how do you fulfill your ethical duty to withdraw, but your legal duty at the same time to your client not to divulge confidential information that may paint your client in a bad light with the court? Because certainly, if you tell the court that the reason you are withdrawing is my client is frustrating the administration of justice, that's not going to cast your client in a favorable eye with the presiding magistrate. The magistrate might come down harshly on your client, who then wants another attorney, and the magistrate might say, well, you must now proceed on your own, because the magistrate's anger, frustration at your client might then come to the fore because you've made the disclosure. So how do you go about applying for leave to withdraw, but in a manner that you fulfill your ethical duties to your client and your legal duties of not divulging confidential information, bearing in mind the attorney-client privilege that exists even between a candidate attorney and the attorney. Although it's called attorney-client privilege, it applies even to the candidate attorney-client relationship. How do you go about doing that? Anyone? Maybe Celeste, if you...
Yes.
Maybe if you can, how did you go about doing this practically in court?
Okay, so after consultation with the client and my principal, he then just the client got frustrated and he said, fine, then I don't want you as an attorney. And then we asked him, are you ending our mandate? And then he said yes. And then I went up to court and I put it to the court, my mandate has been terminated, and then the client is gonna either get another attorney or he's going to proceed on his own. And it was a Schedule 6, so it was a bit hectic, but the magistrate asked him questions and then he said, no, he's ending my mandate. He wants to do his own bail application. So that's how I went about.
Yes, and that is good advice. The way that your principal advises there is the preferred route in order to avoid a compromised situation in court where you might have to divulge or potentially have to divulge confidential attorney-client privilege. It is better to consult with your client and put your client in the position where he ends the mandate. Even if you can't, of course, force your client to end the mandate, but try as best you possibly can to manipulate the situation in such a way that your client sees the wisdom in terminating the mandate. That way, you can quite readily, in court, get the magistrate to grant you leave to exit the matter. And as you have mentioned, Celeste, even when an attorney says to the magistrate, my mandate has been terminated, the magistrate has a responsibility in criminal court. It's very different to civil court. In criminal court, the magistrate has a responsibility to make an inquiry with the accused as to whether indeed he is freely and voluntarily terminating his attorney's mandate and whether the attorney is telling the truth about the reason why he wants out of the matter. And so what often happens, apart from terminating mandates, what often happens, attorneys would come to court and use the reason that the client has not paid for services. or the attorney will say, I don't have financial instructions. You know, that's the common expression that is then used in criminal court, as I think I've also heard in civil court before me. And so what that essentially would then entail in criminal court, the magistrate would then have to inquire from the accused whether indeed the reason that the attorney is giving for wanting to withdraw is genuine, whether it is truthful, whether the client is aware that the attorney is applying. And this is why it's so important for you, if you want to withdraw, it's so important for ethics in criminal practice. You cannot spring this in open court with a magistrate, because ultimately the magistrate is going to make certain inquiries with the accused. And if your client was not properly informed and consulted about this in advance, he's going to embarrass you very likely in saying to the court, I know nothing about this. This is the first I am hearing about this. And then the magistrate is forced to then adjourn the proceedings, have it stood down, so that you can then properly consult with your client and explain to your client what you are about to do. So ethics in criminal practice, I'm talking about pleadings, about the admission of guilt. A lot of that has also to do with proper preparation and understanding what you are going to do in criminal practice, in criminal court, the language you are going to speak, what the language in which the proceedings are going to be conducted, applications that you are going to make for a withdrawal as attorney, whatever the case might be. This is all part and parcel of you fulfilling your duty to be competent as a legal practitioner, and therefore the ethical duty to your client to keep your client informed and respect your client and his rights to understanding the process and participating in the process meaningfully, and not just being there and on some sort of ride that he is not able to control because he doesn't understand it. It wasn't explained properly to your client. This is all part and parcel of ethics in practice that is so crucial when you are practicing in criminal court. I'm not sure if there are any questions that you have that you want to then deal with, that you would like me to deal with, but in this slide that I've got up there, I deal with then the issue of withdrawal as an attorney. I know it's dealt with in your notes as well, but it's an important part of criminal practice in knowing how to withdraw as an attorney, because it's not a matter of simply going to court and telling them the magistrate. Also, it's very important that the timing of a withdrawal is very important, because if you are trying to withdraw as attorney on the day of a trial, it is a lot more difficult to persuade the magistrate to allow you to withdraw on a trial day. It is a lot easier if you make the application at the earliest opportunity, at the most opportune time. And so I've often seen in criminal court before me and other magistrates I've seen where attorneys come to court on the day of a hearing and the prosecutor is ready to go. Trial witnesses are here. With some witnesses have come from afar, traveled a distance, expended money, has taken time off work, and you come to court and all you're going to do is stand there, your client hasn't paid you, or you're frustrated with the matter and now you want to withdraw. The state has gone to great expense to get the matter ready for trial. I've often seen on trial days where magistrates, judges refuse to allow legal practitioners to withdraw on a trial day. If you foresee that this is likely to be something that you are going to need to do, then the ethical way to do this is to plan and to actually withdraw in advance of the trial date. So what usually happens in criminal court is a matter is postponed for a trial date, very much like in civil court. In civil court, you don't just go to court on the day of the pre-trial hearing and there's a trial date that you then start. No, there is a postponement, and it's usually a period of a few weeks and sometimes a few months, depending on how busy a particular court is. So there is quite a bit of time between hearing dates. And of course, as part of good trial preparation, you also don't start to prepare for trial just the day before, especially if it's a complex matter. As Claudia spoke about earlier, a good advocate, a good attorney is one that comes well prepared, and that means preparation before trial, usually a week, maybe even 2 weeks, dependent on the matter involved. So like with civil matters, where you have your expert witnesses, the expert witnesses reports, where you might have an inspection in loco, where you might have meetings of experts and meetings with witnesses and so forth. These things are happening all in advance, and some weeks, maybe a little longer, some months before the actual hearing. Sometimes in the less complicated matters, the legal aid attorneys are so overworked and burdened, they sometimes don't have time to prepare weeks in advance, and it happens maybe a day or 2 days before trial. But with legal aid, you know, there are, I find that there's a bit of a different set of rules that seem to apply for them, and withdrawals, it's usually because the clients have terminated mandates. But for the average attorney in private practice who is going to withdraw because he does not have financial instructions or client is not cooperating, my advice to you is, if you need to withdraw, do so a week, possibly even longer. Go speak to the prosecutor. He's got the files. They will usually have the files. They'll usually be working on the files. The prosecutor can draw the matter, can call up the matter in advance, even if he calls it up 2 weeks before, just so that you can come to court, bring your client there, make sure the client is there, and then you bring the application to withdraw, so that the magistrate can then know that you have fulfilled your ethical responsibilities of acting timeously. You have not wasted the court's time. You have also not wasted costs, so that if there is a postponement of the matter, that the prosecutor can then inform their witnesses timeously and not incur unnecessary costs. All of this is part and parcel of your responsibilities as an ethical criminal legal practitioner. And there are times when, yes, you might come to court on the day of a hearing and you might then have to withdraw because circumstances might be such that you could not have anticipated this. But it should not be because you were negligent or because you delayed your consultation or you delayed your trial preparation. Bear in mind that when you are applying to the court to allow you to withdraw, you're asking the court for an indulgence. And negligence on your part is not only an unethical practice, it's not only grounds for the Legal Practice Council to take steps against you, but negligence is grounds for the magistrate to force you to continue with the matter and not allow you to withdraw. And bear in mind that magistrates can do so, and I've seen some magistrates actually refuse a request by an attorney to withdraw, and the attorney ended up running a long trial and not being covered for fees. So please bear in mind that a lot of part of criminal and civil practice is about preparation. Okay, if we can just break for 5 minutes, and then we can take a bathroom break for 5 minutes, and then we will resume at 11:45. Okay?
Okay.
Thank you.
Is this lecture still on the go? I've got no sound on my side. I'm sorry to interrupt if I am. I can hear nothing. I'm still on ethics and criminal practice screen. Oh, that's it.
We're on a break.
We're all in the same place, Gillian.
Okay, good. I'm not alone.
Okay, I'm back. My apologies that we took a bit longer. Are we all back?
Yes.
Are we all here? Okay, thanks. My apologies for that, but we'll carry on. So, so you'll see we've gone through the criminal practice, the ethics. I've spoken in length about ethics in criminal practice, and that's a crucial part of trial advocacy. And you will see when you get the notes or the slides that this is something that's tied in. The ethics in criminal practice is tied in a lot with you as a practitioner understanding your role firstly as a criminal practitioner, understanding your client's rights, and understanding your responsibilities as an officer of the court, and understanding that you have a duty also to uphold the law and the Constitution, which is the primary law or the supreme law of South Africa. And you will then also see, apart from some of the techniques and ethics in cross-examination, in presenting a version that is not false, in not presenting a version that you know not to be true, there's also certain ethics in how you cross-examine witnesses. So, for example, when cross-examining a victim in a sexual offences matter, cross-examining children, there are certain techniques that need to be adhered to, certain conventions and practices that you need to ensure that you satisfy in order to ensure that you fulfill your duty as an officer of the court, whilst at the same time balancing that with your responsibility to ensure that you are competently representing your client. So this is important when you're preparing your cross-examination and your questions for cross-examination. So understanding how you are going to approach a minor who may not be testifying in open court, but may be testifying through the use of the camera facilities that we have. In some courts, the minors do not come into the criminal court to testify, but they are sitting in another room with a child minder or child carer with the minor, and then when the child is being called as the witness, the proceedings will then be explained to the child in very simplistic language by the presiding officer with the use of the carer or child minder that is sitting with the minor. And it is not the easiest thing when you are cross-examining the child. You need to understand that the language that you use should be appropriate for the witness that you are questioning. So, language using words that a child would not be very familiar with. Vagina, some other descriptive words of organs, sex organs. You need to find a way in your preparation to understand how best it is that you can be effective as the practitioner questioning a particular witness whilst at the same time fulfilling your responsibility. And that is all part of ethics in cross-examination. When you're dealing with a victim of either a sexual crime or a violent crime, often they will break down into tears. Adults, females, and even males, they'll break down into tears during a cross-examination because they are reliving an experience that conjures up difficult memories that are not pleasant. And so part and parcel of not only criminal practice but civil practice also. Civil practice dealing with wrongful claims arising from the death of a person or the loss of a limb. It's no different in criminal practice when you are preparing for cross-examination and actually cross-examining. You need to be mindful of certain limitations that are applicable because you must conduct yourself within certain norms and certain ethics. And it is not simply about being properly attired. It's not simply about having the proper decorum in court. Ethics in criminal practice is not simply about coming on time. It's everything related to what you do, how you do it, and balancing that with your responsibility to your client to present a case competently and also to ensure that he's right to a fair trial and to a speedy trial. All of this is then upheld. And finally, on ethics, an important part of ethics is about receiving briefs. If you're an advocate and working on a referral basis in the advocate's profession, in criminal court, much of the rules have changed or have been relaxed. And so to the extent that some of this is not applicable to the independent advocates or advocates who have a Fidelity Fund certificate entitled to take clients directly from the street, those advocates still working on a referral basis in criminal court. It's usual, it's customary as part of ethical practice to inform the court as to the instructing attorney that has briefed you. It is not necessary that the instructing attorney has to be present in criminal court at the time when the matter is being heard, but it is customary for the advocate to place on record before the court who the instructing attorney is, so that if the advocate of brief cannot be contacted and there's a need to contact the firm, the magistrate and the prosecutor will then know which firm to contact for purposes of the particular matter. So, unless there's anything specific that anybody wants to ask, that is, what I had in mind to explain and discuss on the question of ethics in criminal practice. And unless someone has something to ask, yes, you got a question, yes.
It's not really a question, but
and
comment
is it
regarding cross-section. Sorry?
Is it Tamsanga speaking?
Yes, Prof.
Okay, yes.
It's a comment regarding cross-examination, especially when it comes to police officials. I feel like they are overly protected by the courts. One, you can just see they are lying on the stand. They actually testify something which is totally different from their statement. And the magistrate will always try to protect them, and it's always frustrating for the defense attorney because you are almost every time you ask a question, the magistrate will tell you, no, you can't ask this, you can't do this, and the police officer is just cruising and lying throughout the testimony. How do we handle such situations?
All right, it's a good question because again, I've also experienced that in court, and because of that, I've learned, and when I've sat on the bench, I've tried to make sure that I don't descend into the arena and be perceived as protecting, the police officer, because that is something that I do know that attorneys, advocates have that impression at times, and it's a negative one. It does not speak well of a judicial officer who comes across as protective of a police officer. And just giving a comment on this, I'll give you my sense of it shortly, but where much of our impression about the courts is based on perception. And sometimes what we perceive is perhaps not always true, but our beliefs are based to a large extent on perception. And the public's belief is also based on their perception of what is happening. And in as much as an attorney perceives a judicial officer possibly protecting a witness or protecting an investigating officer, it's conceivable that a member of the public sitting in the gallery or an accused person getting the similar impression that the hearing is not fair or being handled fairly because his perception is that there is a bias on the part of the judicial officer. And we must, as legal practitioners, as judicial officers, as aspirant prosecutors, we must try to address that and engage with each other and try to ensure that we operate in a manner that does not give that perception and that we're always walking with our best foot forward first. But coming to how you handle that, again, it's not easy, and there's no easy answer to this, because in many instances it by and large depends on the issue that you are trying to examine the witness on, which the magistrate is seemingly not allowing you to pursue. And what I would advise you to do is, where you are confident that you are being denied a fair opportunity to cross-examine a witness on something crucial to your client's case and something on which you are confident you ought to be entitled to ask, I would advise you that what you should consider doing is to ensure that you respectfully inform the magistrate that you place on record that your client is being denied a fair opportunity to present his case because the presiding magistrate is refusing to permit you to question the investigating officer or witness on a matter which you verily submit to the court, is an issue that you ought to be allowed to examine on. And the reason that you should try and make sure that you, in a very respectful way, place this on record is because in the event of an appeal, you can use that as one of your arrows, one of your grounds on which to argue that the trial was not conducted fairly, because, and then you can list as the ground of appeal or a ground of a review that the magistrate denied you the opportunity to cross-examine Mr. So-and-so, an investigating officer, on the following relevant legal issues on which the magistrate ultimately made a finding. And if the magistrate made a finding on an issue that you wanted to examine the witness on and you were denied the opportunity of examining, mention that in the review or the appeal application. But in the heat of the moment, when it is happening in court, be calm, not allow yourself to become unruly or disrespectful, but probably the best course that you can take is to place that before the court, or possibly if you feel that it is something you can't simply let go, try and rephrase the question that you are asking, and possibly try to do it after you've placed this that I mentioned, after you've placed it on the court record. Because sometimes what often happens, particularly with some more junior magistrates or some magistrates less experienced or some magistrates who may not necessarily want an appeal, they would possibly soften their approach after you have recorded that there is an issue that you regard as going to the root of the question of fairness. They may very well, I found that has at times softened the magistrate, especially where they are facing a potential appeal or ground of review. I hope that that's been somehow of assistance to you, Thamsanqa, in how you can possibly approach that.
Yes, Prof. Thank you so much.
Okay, so then the next part of what we are doing and what will be important for the practicals that we're going to do in our face-to-face session is then consultations. I see it's 12:05, just after 12:05, and maybe we can just get some direction so we can understand. What I was hoping to do is to finish off at about 12:30, and would it be possible if we can then have a half an hour lunch break and resume at 1 o'clock and finish at about 2:15? Would that be in order with you?
Yes.
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 Okay, so let's carry on then for the next 20 minutes, and then let's do from 1 o'clock, and then we can finish earlier than the scheduled 3 o'clock. So we won't have a tea session in the afternoon, and we will have a shorter lunch break, and in that way we can then also finish up a bit earlier. Okay, so then the consultation process itself, and again here I've discussed quite a bit when I dealt with ethics. I've discussed quite a bit about consultations and about how you deal with a consultation. But what I want to deal with here more pertinently is some of the specifics that one needs to consider when consulting with a client. So here what you need to bear in mind is you need to know the purpose of the consultation. The objective of a consultation will invariably determine what some of the important material or issues or aspects that you will need to consult on. And bear in mind that a consultation is a process. It is not necessarily simply an event. It is not simply a once-off event, but a consultation would be a process as you would have it in a civil matter also. And in the course of a criminal matter, invariably you will consult at different stages in a matter. So you will have your initial or first consultation, and I'm going to assume, and you must assume for present purposes, that the first consultation I am referring to is a consultation invariably probably before a client's first court appearance. But it can happen, and it does sometimes happen, that your first consultation with a client may well be after the client has already had a bail application. It may well be that your first consultation happens after your client's first appearance. And for this reason, it is very important that when you commence with your first consultation, you need to establish where in the legal process your client's matter is. You need to establish whether your client has already, for example, appeared in court. You need to establish whether your client is in custody. You need to establish whether your client has already pleaded to the charge. And so for this reason, you need to establish the status of the matter at the time when you are first consulting a client or someone related to the client about a matter. Because you must bear in mind that your first consultation does not necessarily mean that the matter is at its beginning stages. It may very well be that you are the second attorney or the third attorney or practitioner who's going to handle the matter. We've spoken about attorneys or practitioners withdrawing from a matter. It may well be that you are engaged in a criminal matter where there has been a withdrawal of one or more practitioners and you coming on board sometime later in the course of the matter. But when you are meeting the client for the first time, there are certain basic things that you would need to consult about. One of the first things that you need to ensure that your client understands is the concept of professional or legal privilege. A very important part about criminal practice, but also with civil practice, is that clients don't always trust the legal practitioner. Particularly, I find this in criminal matters, where people have done something wrong, or they think they've done something wrong, and they're dealing with a practitioner that they don't know. Invariably, human nature takes over, and there is a reluctance to be completely frank and honest with the legal practitioner. And for this reason, it becomes crucial that at your first meeting with the client, with the accused, you need to explain to the client that everything that is said between the two of you in consultation is protected. There are confidentiality rules that apply. that unless the client consents to you making disclosure of certain information, you are prohibited from making that disclosure. I have found that for most clients, that tends to put them at ease, and that ease tends to grow with you. The more they are dealing with you, the more comfortable that they become with you. They begin to see that they can trust you and rely on you. They open up a lot more and a lot easier because they know that you will exercise discretion, and that they know that you won't simply divulge things that they have told you in confidence. And confidence and trust is a critical part of being a practitioner in general, but in criminal work, especially, your client's life to some extent is in your hands. His freedom or his incarceration is in your hands. And so at times when you are representing a client in a criminal matter particularly, the stakes are quite high. Because if your client is convicted, you may be part of a process that results in your client going to jail or going free. And so trust and confidence in you and your ability becomes important, and it is important to try and establish that trust from as early as possible in the process. And for that reason, try in your first meetings with the client to put the client at ease, explain the concept of privilege and how your client can depend on you, and how you will protect the confidence that the client has in you and in giving you confidential information. Explain that to the client. Apart from that, of course, there is the usual other things that you will need to discuss. If it's a paying client, then of course discuss the issues of fees, the rates, deposits, times of payments, the usual things that you would even do in a civil matter. Of course, a critical thing, of course, that you need to discuss with the client, it is imperative as part of your ethical responsibilities, you need to bring to your client's attention that he is not compelled by our law to appoint a legal practitioner that he must pay for. You need to inform your client that he has the right to legal representation at state expense. Often what happens is clients are not aware that in criminal matters they have the right under the Constitution to legal representation at state expense if they cannot afford it. And you must explain to your client the different types of legal representation available where he does not have to pay. That it is not only legal aid, but there is pro deo counsel available, pro bono attorneys, and you need to explain to your client whether you are prepared to accept an instruction or a brief on any of these bases where the client himself does not have to pay. That you need to explain to the client up front, because that is one of the rights that a criminal client has, which is not a right that a client in a civil matter has. Although in civil matters there is legal aid, but in a limited number of types of cases. Then of course in a criminal matter, as in a civil matter, it's important that you get clarity from the client on the nature of your mandate and its extent. You need to know exactly what part of the criminal process your client wants you to actually handle. Is it just a bail application? Is it the whole trial? What exactly is it that you are being asked to do? Sometimes your mandate could be as simple as the client simply wanting a second opinion, some wanting some guidance. A simple matter of the client is in custody and it's a Friday afternoon and the family just wants you to come and try to get the person out. out on either bail or on a police warning of some sorts. So get an indication of what exactly the nature and extent of the mandate is. This is very important that you get at the first consultation. And that all depends on what the purpose of the consultation actually is. And again, as I mentioned there in the second slide there, another issue that's important is you need to establish whether your client has made a statement to the police, a written statement. If so, make sure you get a copy. If your clients have not made a statement to the police, make sure you advise your client not to make a statement unless you are present when the statement is being made. Advise your client of his rights to remain silent. Advise your client that the right to remain silent means that he does not have to make a statement to the police and that his remaining silent cannot be used against him in a court of law. Often what happens is clients are not aware of this right and they think that because the complainants have made statements, they often think that they might also need to make a statement, otherwise their version is not before court. Remember that some clients are not au fait with the process. They haven't been through this before. The more seasoned, hardened criminals have been, and they will know not to make statements. And guaranteed, they won't make a statement. But some do make statements, and if so, you need to make sure that you get that, and you need to see whether the statement amounts to a confession. And if so, you need to ensure, you need to see whether the requirements for a valid confession has been met, or whether there has been coercion of some sort. So if your client has made a statement, if a statement has been made, obtain a copy, but then consult with your client about the circumstances surrounding the making of that statement. Try and get instructions about whether it was made freely and voluntarily. So get instructions about the environment under which that statement was in fact made. Why did your client make the statement? To whom did he make the statement? Those are critical things. What was promised to your client when he made the statement? What led to him making the statement? So look at the events before, look at the events after, to try and get details about the statement so that you can apply your mind to the question whether the statement is one that you need to challenge in a court of law. Because often what happens when an accused has made a statement, the prosecution intends to use that statement at some point in time, and usually at trial. And if that's the case and there is damaging information in there, damaging to your client's case, it may well be that you want to bring an application to court to have that statement declared to be inadmissible as evidence in a court of law. And that might require you to bring or to have a trial within a trial. And so at your first consultations or in the initial part of the process, establish information about statements that your clients may have made. And if not your client, an established statement that may have been made by co-accused. It sometimes happens that your clients are part of a group that is being accused, and one of the accused or more of the accused have made statements. If so, obtain copies of those statements and determine whether they have implicated your client in the commission of the offense. And if they have implicated your client in the commission of the offense, you need to take instructions about that, because you may want to also bring an application to separate the trial of your client from that co-accused, so that there are separate trials that are going to run. So it is very important to understand the objective of your consultation and the reasons why you take certain details from the client. It's all about, at times, it's all about strategy. Understanding what strategic moves you are going to make during the conduct of your trial, what preliminary hearings need to take place, what interlocutory applications may need to be made in order to make your trial a lot easier for your client by perhaps having confessions struck out, perhaps having an ID parade declared invalid, and so on and so forth. So it's crucial to know why you are asking certain questions. So although I don't go into detail in these notes about why an oral statement is so important, or why a written statement, getting a copy is so important, it is important for you to understand because it's how you're going to strategize going forward. Taking details about the age of the accused, that becomes important because in criminal court, you have different courts for adults than for juveniles, for minors. So if the accused is a minor, you need to ensure that he is brought before the correct court. If some of the accused before the court are majors and one or more is a minor, then the matter must be referred to the juvenile court. And so getting the age of your client is so important, because you need to be able to ensure that your client is brought before the correct court. Then also it's very important to know the place of the offense. So reading the charge sheet becomes so important. Getting a copy of the charge sheet becomes so important as early as possible, and consulting with your client about the alleged offense and the place where it is alleged to have occurred, because it might be that you need to challenge jurisdiction. Remember that if you don't challenge jurisdiction early enough in your plea, for example, you would then be taken to have consented to the jurisdiction. Much like in the magistrate's court, where if you don't challenge jurisdiction early enough, it might be then argued that you have consented to the court's jurisdiction. It is also important, particularly with bail matters, to know the date of your client's arrest. And the reason that that becomes so important is because you must remember that we have the 48-hour rule pertaining to when an accused must be brought before court for the first time. And the rule is that an accused person must be brought before court no later than 48 hours calculated from the time of his arrest. And where an accused is brought before court outside of the 48 hours or after the 48 hours, the magistrate is obliged to strike the matter and the accused will be released. I know I've done that on a number of occasions. And so it is important for you, if you are coming early on in a matter, on a bail application or your client's first appearance after his arrest, is to check with the prosecutor, look at the docket, look at the charge sheet. The date of arrest should be in the charge sheet. And that is where you will get that, and then see when the client's first appearance is, and then make objection if an objection is needed. I see it's 12:30. Let us adjourn there and let us resume there at 1 o'clock and continue from there.
Cool.
Thank you.
Thank you.